Good afternoon, Lisa. My name is Mira Elsey and I'm a licensed conveyancer here at Harbourstone Legal and Property. How are you going today?
Good, thank you. How are you?
Good, thank you. Thanks so much for taking the time to meet with me here today.
Thanks for having me.
That's okay. So I understand that you signed a contract on the 17th of March to purchase the residential investment property situated at 12 Clifton Avenue, Rosetta from Dominic Hartley?
Yeah, that's correct.
Yeah, great. And just so I'm letting you know, during our meeting here today, I will be taking your instructions and I will be taking notes throughout the meeting. I hope you're okay with that.
Yeah, absolutely.
Great. So during our meeting, I will be asking questions about the contract and we'll be discussing those unusual special conditions which our office identified during our initial contract review.
Yeah.
And I'll also provide some preliminary advice surrounding the enforceability of the contract. And I'll also discuss some potential remedies available and the recommended next steps.
Yeah.
However, in saying all of that, I do just want to quickly mention that as the matter contains some complex legal issues, final confirmation of advice will need to be provided by a senior lawyer. Following them reviewing a contract and any supporting documentation. So you're happy to proceed on that basis?
Yeah, absolutely.
Great. So are you able just to firstly explain to me in your own words what's happened and what your main concerns are surrounding the contract?
Yeah, absolutely. So after signing the contract, your office identified 3 unusual special conditions within the contract. The first one requires me to pay an additional $45,000 directly to the seller as an access fee. That was included in the purchase price. The second required me to retain the existing tenant for 24 months without reviewing rent.
Yep.
And then the third was for me to pay the full purchase price, but also take responsibility for the property at settlement, but the title will remain in the seller's name for another 12 months.
Yes, that's exactly right. And they are quite strange conditions. So thanks so much for explaining that. Before signing, what were you told about in relation to the $45,000? Like, was there some sort of explanation by the vendor or?
Yeah, the seller just said it was an access fee and that I had to pay it directly to him.
Yeah, okay, that is quite strange. And in relation to the tenancy, were you given the complete tenancy agreement or at least just a detailed explanation about the tenant and the surrounding circumstances before signing the contract?
No, I received very limited information.
No, okay. And what explanation were you given in relation to the delayed transfer of title in relation to the 12 months not being registered?
Yeah, so the seller said it was connected to another development matter, but didn't explain that well at all.
Yeah, okay. Thanks for letting me know that. So what outcome are you hoping to achieve from our meeting here today?
Well, ideally I'd like to proceed if the conditions can be removed. Otherwise, I'd just like to withdraw from the contract.
Yeah, okay. So just to confirm, your main concerns are whether the conditions are firstly lawful, and whether they can be removed, and whether you may challenge the contract if the seller refuses to amend them. Is that correct?
Yeah, that's it.
Great. Thank you so much for confirming that. Based on the information available, this is a written contract for the sale of the residential land between you as the purchaser and Dominic Hartley as the vendor. So just so you're aware, the purpose of the contract is to record the agreement for you to purchase the property and Dominic to sell the property to you in exchange for the agreed purchase price. And within that contract, it also records matters such as the purchase price, the deposit, and any special conditions that you have agreed to. So although the contract appears to be a valid REIT standard form contract to sale, each special condition still must comply with the law, so it still must be lawful. So the fact that a condition appears in a signed contract does not automatically make it immediately lawful or enforceable.
Okay, and so does that mean that the contract might be valid but the individual conditions might not be?
That is exactly correct. So our court may potentially refuse to enforce a particular condition while also allowing the remainder of the contract to continue. However, that will depend on whether the condition can be separated from the rest of the agreement. Is that making sense?
Yeah, absolutely.
Great. So I'll just now briefly explain the usual elements for a contract to be considered legally binding. So there are 6 key principles. The first being offer, which is where one party proposes terms. Acceptance, where the other party accepts those proposed terms. Consideration, meaning something of value is exchanged between the parties. So in this circumstances, you're exchanging funds, the settlement amount, the purchase price, in exchange for the property which Dominic is providing. The fourth principle is intention to create legal relations, meaning that both parties must intend for the agreement to be legally binding. Capacity is the fifth key principle, meaning both parties must be legally capable of entering into a contract.
Yeah.
And finally, legality, meaning that the purpose and the terms of the contracts must be lawful.
Okay.
So based on the information available, the contract does appear to satisfy the usual elements of a contract to be considered legally valid.
Yep.
However, the legality and enforceability of the special conditions alone remain questionable. So does that make sense?
Yeah, yes it does.
Great. Do you have any questions before I move on?
Not so far.
Yeah, no worries at all. So just letting you know, the contract appears to have been validly formed when it was signed. However, this does not mean that every special condition would necessarily be upheld by a court. So a court may consider the wording and purpose of each condition and how that is affected within the entire contract.
Yeah.
Whether the condition requires unlawful conduct. Also whether the condition was properly explained to you before signing the contract.
Yeah.
And also whether you understood its legal and financial effect. Another thing is whether the whether the seller engaged in misleading conduct or misrepresenting it.
Yeah.
And also whether the condition can be removed without affecting the remainder of the contract. So if it can be established that you can still proceed with the purchase with a condition being removed, then that is something a court would consider. So at this preliminary stage, I do have very serious concerns about the three conditions, which is I would certainly recommend obtaining legal advice so they can provide some final confirmation for you.
Yeah, absolutely. And does that mean I should stop doing anything under the contract?
So you shouldn't just simply ignore the contract or terminate it without getting that legal advice.
Yeah.
However, at this stage, I would certainly recommend that you do not pay at least that additional $45,000 or sign any further documentation until a senior lawyer has reviewed the matter as a whole.
Yeah.
And they'll be able to let you know of your rights and obligations.
Yeah, okay.
So moving on, just to discuss the actual conditions that I have concerns with.
Yeah.
The first concern being that additional payment of $45,000. So a payment connected with the purchase should be ordinarily and accurately recorded within the contract.
Yeah.
To be disclosed, which is the purpose of the contract. It's supposed to be the written agreement between the parties.
Yeah.
And an amount paid directly to the seller outside the purchase price could affect things like duty and taxation, and also just financial and settlement records. So it's very important that should be accurately recorded in the contract. So it also raises concerns under the Australian Consumer Law, being Schedule 2 of the Commonwealth's Competition and Consumer Act, which deals with misleading representations. Because this could be considered misleading conduct by the vendor. So I'm not suggesting that fraud has definitely occurred in this situation, but the arrangement is quite different, not something that we've seen, quite irregular, which requires, I feel, urgent investigation.
Okay, yeah.
It also raises questions about breaching the Real Estate Act as well. So that's another thing that should be investigated by a senior lawyer.
Yeah.
Do you have any questions on that first condition?
No.
Great. So just moving on, the second concern is the condition requiring you to retain the tenant for 24 months without actual rent review. So purchasing a property with a tenant and with a residential tenancy isn't unheard of at all, and isn't necessarily unlawful. However, you should receive the full information up front about the existing tenancy, which includes the lease term, the rent and bond records, and also right and obligations of all parties.
Yeah.
So this condition must also comply with the applicable residential tenancy legislation, being the Residential Tenancy Act, and it cannot lawfully remove statutory rights.
Yeah.
Do you have any questions on that condition before I move on to the third?
No.
No worries. So the third concern is the delayed transfer of title, which is a very strange type of condition. This condition requires you to pay the full price and assume responsibility for the property while the seller remains the registered owner for another 12 months, which is something that I've never even come across before.
Yeah.
So this could expose you to significant risks, including the seller becoming insolvent, and another dealing being registered. That's another situation that can happen, which means you're left with a dealing that you weren't aware of at the time of purchasing. And also raises potential concerns about disputes over insurance and rates and maintenance. So
Yeah.
although you may obtain an equitable interest, you would not become the registered legal owner until that transfer was actually registered. So although settlement was occurred, you won't be the registered owner for another 12 months, and I do have concerns with that. And it also does raise concerns with the Transfer of Land Act as well,
Okay.
and the Land Titles Act.
Yeah. And would you recommend that I accept any of these conditions?
No, not without significant amendments to those conditions, and also final advice from a senior lawyer. In particular, I would not recommend paying the full purchase price without receiving the registered title at settlement, and that's a huge thing for me, because as far as we're concerned, you can pay that purchase price and they run away.
Yeah.
So that is a very important one. Not that they're all very important, but that one is very strange in particular.
Yeah.
So moving on to some remedies, there are several potential options available to you in terms of remedies.
Yep.
So the first option is to negotiate a written variation, removing or amending the existing conditions within the contract. So potentially this may include removing the $45,000 payment, and also obtaining residential disclosure, or disclosure about that residential tenancy agreement, and also requiring the title to be transferred at settlement.
Yeah.
Now the advantages of that remedy is that you may still be able to proceed with the purchase contract without the need for legal proceedings. However, the disadvantage is the seller may refuse, and they're absolutely within their right to do so, just to refuse.
Okay.
Now, the second option is to seek advice about challenging the contract or potentially just rescinding from it as a whole.
Yeah.
Now, this may be available if the conditions are considered unlawful, or if you were induced to sign through those misleading representations made by the vendor, or misleading conduct, I should say. Now, the advantages of this is that you may be released from quite a risky transaction and you sort of just run away and choose another property.
Yeah.
Now, the disadvantages is that the seller may dispute your right to withdraw, and an invalid termination of the contract could expose you to legal breach of the contract and also forfeiting that deposit, which is why a senior lawyer would certainly need to review that option, should that be a remedy you're wanting to pursue. Now, another option is to consider whether the conditions can be removed, not removed, just separated from the existing contract.
Yeah.
So the advantage is that the purchase may be able to proceed without the conditions included. However, the disadvantage is that the severance may not be available if the conditions are fundamental to the existing contract. So basically, if the court determines that the contract cannot proceed without those conditions.
Okay.
Is that making sense?
Yep.
Great. And just one other remedy, so the fourth remedy that comes to mind is to seek damages or compensations if you do suffer a loss.
Yep.
Now, the advantages of that is that you may be able to recover financial losses.
Yep.
However, the disadvantage is that a claim may be costly and it can be a quite time-consuming process. Also because it's not automatically releases you from the contract as well.
Yeah.
So with all those remedies mentioned, do you have a preference to any of them?
Yeah, so it would be to have the conditions removed and then continue with the purchase, if that's possible.
Yeah, okay, so you are quite sold on property. You want the property, just concerned about those conditions?
Yeah.
Yeah, that's understandable. So we can certainly raise that option with the senior lawyer, and if appropriate, seek that formal written variation from the seller. However, again, that'll just be confirmed by a senior lawyer, once they review your entire matter.
No worries.
So there are several matters that would need to be referred to a senior lawyer before the final confirmation of advice is provided. So this would include whether that $45,000 payment, as per that first condition, is unlawful. Also whether the seller's conduct is considered misleading. Now, in relation to the tenancy condition, just whether that tenancy condition complies with the residential tenancy legislation, because there is a few pieces of legislation that should be reviewed in order to make sure that these conditions are lawful. Also whether sufficient tenancy information was provided and disclosed at the time of the contract, which it appears it wasn't. And in relation to that transfer of title conditions, whether that delayed transfer condition is lawful and enforceable. And basically with all the conditions as a whole, whether they can be severed from the contract and separated. Also whether the contract may be challenged or simply rescinded, and also whether what urgent actions should be taken before settlement. So is that all making sense?
Yeah.
Great. So when's settlement currently due?
It's in approximately 3 weeks.
Approximately 3 weeks, perfect. So given that time frame, I would certainly treat this matter as more urgent because these reviews do take time. So I would treat that as urgent. So until final advice is provided, I would recommend that you don't pay that $45,000 as I mentioned a moment ago. And also do not sign any variation or preserve all correspondence with the seller or agent.
Yeah.
So a senior lawyer will need to confirm your final legal position before any formal notice is issued and before your final confirmation advice is provided as well.
Yeah, I understand. Yeah.
Great. So just to confirm my understanding of your instructions as a whole, you would like our office to urgently review the signed contract and the special conditions, as well as investigate that $45,000 payment, obtain and review the complete tenancy documents from the vendor, as well as assess the delayed title transfer arrangement, also determine whether the conditions can be removed or may be varied in a way that's preferable to yourself. As well as approach the seller about a written variation if appropriate and refer the matter to a senior lawyer for that final legal advice before any position is taken. So is that correct?
Yeah, absolutely. That's correct.
Great. So in order for us to do that, we will just need a few of the information, the documentation. So just, if you don't mind, can you please provide our office with the documents referring to the $45,000 fee and any advertisements for the sale or particulars. Also, all correspondence with the seller or agent would be important to have if there was any discussions about the conditions. As well, if you don't mind, we can get the complete tenancy arrangement and the bond information. Would you be able to get that from a real estate agent, do you think?
Yeah, I should be able to.
Great. We'll also just require any explanation regarding the delayed title transfer and as to what conversations were made in relation to that. We'll also just require your finance documents and the confirmation of the settlement date too. So once we review all those documents, we'll review the matter urgently and refer it to a senior lawyer to provide that final confirmation advice. However, before then, following our meeting, I will provide a preliminary advice letter which will summarise our meeting here today and will outline the documents we do require, so you don't have to remember it all off the top of your head.
Yeah, cool.
So before we leave here today, do you have any questions before we sign off?
No, I think everything, that's all covered.
Great. So thanks again for meeting here today and explaining the circumstances. So like I said, I'll get onto that preliminary advice letter, but if you don't mind sending through some of the documents, that would be greatly appreciated.
Yeah, absolutely.
And if you do have any questions at any time of the process, feel free to give me a call or send me an email. But if you have any further questions at all?
No, that's all good. Thank you so much.
No worries at all. You enjoy the rest of your day.
You too.